Good morning. This is Nathan Sanderson. I'm the Executive Director of the South Dakota Retailers Association. Welcome to the webinar on our COVID-19 legal update, practical guidance for employers. We're pleased to be joined by Chris Hoyme. He's an attorney with the Omaha, Nebraska office of Jackson Lewis. Their law firm has a relationship with South Dakota Retailers Association that has gone back for a long time. Chris represents businesses in all facets of employment litigation, and he's a member of the South Dakota Bar Association. Really knowledgeable guy, and so we're in for some good information today. A couple of quick housekeeping items. First, you'll notice a note-taking version of the PowerPoint. You can print that out from the handouts area that you can see on your screen, so you can take notes on that. Also, this webinar is being recorded, and so later on today, after we've wrapped up the webinar, we will send that email out via email. We'll send a link to the webinar, and you're welcome to review it again. Also, on Friday, we're going to be hosting a webinar with the South Dakota Department of Labor regarding unemployment insurance issues. So we've got more information coming up. Now we've got more than 200 people who have registered. We've got 100 attendees who are actually participating on the call right now. And so we're probably not going to be able to facilitate a Q&A portion at the end. We have received many questions in advance, and Chris has incorporated those into his presentation. So after the presentation is over, we're also going to create a frequently asked questions document that will be posted on our COVID-19 page on sdra.org. And so if your question is not answered here, by all means, send us an email, info@sdra.org. Send us an email, and we will make sure that your question is incorporated into that frequently asked questions document that will be posted again on sdra.org on the COVID-19 page. So with those prefatory remarks, I would turn it over to Chris for some practical guidance related to COVID-19. Chris, thank you for joining us.
Thank you, Nathan. Thank you for the opportunity. Again, I'm Chris Hoyme, partner with the Jackson Lewis law firm. We've had over a 10-year relationship with the South Dakota Retailers. We have an office in Rapid City. I'm a member of the South Dakota Bar as well as a number of other bars, and I've had the privilege of either talking with you on the phone or emailing or presenting live various HR presentations we've done over the years. Today is an update on COVID-19. Obviously, a very serious issue, safety issue for all global citizens. In terms of brief background, presently, as of this morning, globally there were 440,318 cases, approximately unfortunate death toll of 19,752. In the United States, COVID-19, 55,200 cases, approximately 800 deaths. In South Dakota, currently, as of this morning, based on my review, 30 cases, 1 death. Consequently, significant legislation has been passed by the federal government. Guidance is being given by a number of state and federal agencies, and employers large and small are reviewing their options in terms of complying with the safety orders, requests, and recommendations from federal, state, and local governments. What we are going to discuss today is a very fluid situation. It is a direction based on legislation that is a day or two old, that has not been filled in by specific regulations. So understand that we are attempting to give general guidance, but due to the newness of the situation and the laws, there are a number of variables that have yet to be determined. But we will do our best to give you practical advice on how to respond to this terrible situation. Now, there are some excellent resources out there for you as South Dakota employers. One of the best resources I've seen without being self-serving is the South Dakota Retailer COVID-19 page that has a number of links, information. It has links to our law firm's COVID page, which again can provide very valuable information and guidance, general guidance on these issues. The DOL presentation webinar for Friday, I think will be very valuable. I would point you in that direction. Also, the SDRA COVID page has an up-to-date listing of all the statewide and city closures and orders that can and will impact all of us. So if you're looking for current information, I have found the SDRA COVID page to be excellent. Okay, again, we're going to present a lot of information in a short period of time. I'm going to devote a significant part of the presentation to general questions and your questions that have been presented, as Nathan said. Okay, the major piece of legislation from the federal government that can and will impact all of you is called the Families First Corona Response Act. It was signed into law by President Trump on March 18th, 2020. It provides two primary provisions. It creates limited paid sick leave and amends the Family Medical Leave Act to expand coverage for COVID-19 child-related reasons. The effective date of this law that we're about to discuss that will have application to all of you, employers large and small, is April 2nd, 2020. There is some question as to whether it actually is effective before then, but the law specifically says April 2nd, 2020, and until guided otherwise, we will rely on that effective date. The first prong of this Families First legislation is the Emergency Paid Sick Leave Act. Emergency sick leave. It provides that all employees of a covered employer are eligible. That's all, every employee you have. A covered employer, as to whether or not this applies to you, includes any public agency and any private entity with fewer than 500 employees. Again, very far-reaching, and there is even some current discussion whether this is going to apply to all employers, but right now, those less than 500. If you are an employer that has a number of employees that borders on 500, the definition of how to count those employees, how to aggregate those employees if they are from different locations is fluid right now. And you should seek specific guidance from professionals as to whether or not you get to that limit. If you're close to 500, we need to make sure that you have accurately counted based on the current state of the law as to whether or not the law applies. Okay, the qualifying reasons for emergency paid sick leave are as follows, and that is, is the employee subject to a quarantine or isolation order related to COVID? Has the employee been advised by a healthcare provider to self-quarantine? Is the employee experiencing symptoms of COVID-19? Is the employee caring for an individual who needs to be quarantined and isolated? Is the employee caring for their son or daughter if the school or place for the son or daughter has been closed? And is the employee experiencing any other substantially similar conditions, specified by the Secretary of Health and Human Services. This appears to be a very broad definition of covered employees. And although we'll get to your questions, one question is, what about employees that have not been formally quarantined, haven't necessarily shown any COVID-related symptoms, don't have a doctor's note or a professional opinion indicating they have a condition that could be impacted by COVID, but simply have a very legitimate fear and anxiety of working because of COVID. Generally, in those circumstances, as we'll see when we get to the question, they would not qualify if they cannot medical professional opinion, tie it to COVID. So we have these definitions, but there clearly will be nuances and ambiguity depending on each individual situation. All right, those are the qualifying reasons. I cannot advance all of a sudden. Oh, I got it. All right. What is the sick leave entitlement? Full-time employees are entitled to 80 hours of paid sick leave. Part-time employees are entitled to the number of hours equal to the average number of hours such employee works. Employees working a variable schedule will be based on the number of hours such employee was scheduled to work per day over the preceding 9 months. If not employed for that 6-month period, use a reasonable expectation of scheduled hours during that time, which is vague, I understand, but we don't have any regulations to give us any more specific guidance. So full-time employees, we're looking at an obligation to pay 80 hours of paid sick leave. The sick leave will be paid at the employee's regular rate of pay. The cap is $511 per day and $5,110 total aggregate max that you would have to pay under this provision. If the leave is to care for a COVID-19 qualifying reason, a family member care, then it's at the 2/3 rate, and the cap is $200 per day and $2,000 in the aggregate total. Important provisions. Employer must post notices in conspicuous places about this obligation. The DOL is to provide that notice today. I have not seen it yet, but we will monitor and distribute and get it on the retailer website as soon as we receive it. After the first sick day, the employer may require an employee to give reasonable notice procedures in order to receive paid sick leave. Again, the ambiguity is reasonable notice. If someone is given no notice due to circumstances they can't control, we will not expect them to provide notice. Employers under prohibitions cannot require the employee to use other paid leave first, cannot require the employee to find a replacement employee, cannot discharge, discipline, or discriminate an employee who takes paid leave, meaning retaliation cases. If they say, I think I'm coming down with these symptoms, I need to go home, suddenly they are terminated. We have to make sure that that termination in no way relates to the fact that they were seeking paid leave under this act. Enforcement will be consistent with the guidelines from the Fair Labor Standards Act. So that's the first provision. Paid sick leave that is applicable generally, and we'll show you one small escape opportunity in just a second, that is applicable to virtually all employers. Next, the second prong is emergency FMLA expansion, which provides that employers with fewer than 500 employees, and again, if you're close to that threshold, you need to get some guidance to make sure that you have counted your employees correctly. And the test that appears to be going to apply in counting will be this integration, the integrated employer test. But again, this is fluid and we're waiting for further guidance, some of which came out last night from the DOL as to how to count. but I know many of it, if not most of you, are below that 500 limit and not even close. Okay, who is a covered employer in the second prong? Healthcare provider or emergency responder can exclude employees from these provisions. The definition of healthcare provider and emergency responder are very narrow. So do not anticipate that you're going to qualify unless you have indeed meet a very strict definition. Now, here is your potential escape clause. If you can show that you are a business with fewer than 50 employees, and this provision would jeopardize the viability of the business by having to pay these amounts, this paid sick leave or this enlargement of the FMLA, you can avoid having this apply to you. As you can imagine, we anticipate the regulations that have not been issued yet to be very strict. You would, in essence, have to show that if we comply with these provisions, and we can prove through a balance sheet scenario, basically, that it would put us under, then you will be relieved of compliance. Now, that will be, again, a strict process, and do not anticipate that you can just unilaterally say, well, this doesn't apply to me, this would put us under. And we will attempt, as the regulations come out, to provide the actual protocol and mechanism for presenting that evidence and getting some type of guidance that indeed the law does not apply due to the jeopardized financial viability of your business. Okay. Eligible employee. The only eligibility requirement is that an employee must have been employed for at least 30 calendar days. This does not impact our other FMLA eligibility requirements for regular FMLA, but it does in this isolated instance where we're expanding protection for the care of immediate family due to COVID, it applies to all employees who've been employed at least 30 calendar days, okay? It applies when the employee is unable to work due to the employee's son, due to the need to care for the employee's son or daughter. Sorry, I want to make sure I can see this. Under 18 years of age, if the child's elementary or secondary school or place of care has been closed, or the child care provider is unavailable due to a public health emergency. Public health emergency is defined as an emergency with respect to COVID-19 declared by a federal, state, or local authority. The employee does not get an additional 12-week entitlement, simply adds an additional reason for leave. I have had a number of questions from all of you as to defining this public health emergency. Again, I wish I could be more specific, but what if we don't have an order? What if we have a recommendation or a guidance, but no actual order demanding that the school or child care provider is closed? Again, without specific guidance, it is impossible to give certain advice, but I would guess, I think in an educated manner, that if the governor issues an order that schools should be closed or a child care provider should not be open, even though it's not an enforceable order, that would still qualify under this expanded FMLA leave as defined. Again, brand new law, we're waiting for further guidance. I wish I had more specifics for you at this time, okay? Okay, having trouble advancing, I don't know why. All right, all right. All right, now, the expansion here says the first 10 days of leave that qualifies under this expanded provision. When the schools are closed, child care workplaces are closed and you have to be home, the employee has to be home to take care of them, the first 10 days are unpaid. Subsequent absences for this reason must be paid at the employee's regular rate of pay, a cap of $200 a day and $10,000 in aggregate. If the first 10 days are unpaid, an employee may elect to substitute any accrued vacation leave or personal leave, but it's their decision for the unpaid leave, okay? All right. The employee must provide notice as soon as practical if they're going to request this leave. Again, in this type of fluid emergency type environment, the notice will generally either be waived or it will be so short that it really doesn't afford any benefit. If somebody takes this leave, they're entitled to reinstatement to the same or equivalent position under the FMLA. There is an exception for employers with fewer than 25 employees if the employee's position no longer exists due to economic condition or other changes in the employer's operation that affect employment are caused by the public health crisis. All right? So if we have fewer than 25 employees and we've had to cut out a significant portion of the business or cut out due to the COVID, that employee's job, we may have the opportunity for relief under this expanded provision of the FMLA. Okay, now, if you provide sick leave or if you provide this expanded FMLA leave, there is opportunity for, in many cases, dollar for dollar payroll tax credits. So beginning on the effective date of April 2nd, if you provide this paid leave we've talked about, or provide this expanded FMLA leave, you will have the opportunity to be reimbursed through payroll tax credits. Again, brand new law. We're waiting for guidance from the IRS on what the protocol will be, but there is opportunity for reimbursement, but we just need to know, and we'll receive soon the guidance on how to do that. When we receive the guidance, we'll get it posted on the Jackson Lewis website, and we will get it posted on the SDRA website. So remember this, though, if you are providing expanded sick or child care leave under this act before April 2nd, you probably won't get credit as it stands right now under the payroll tax credits. But after that date, which is fast approaching, you will. Again, a fluid situation, but the opportunity is there. Okay? Now, many of you are faced with the necessity at this point to change rates of pay, to consider providing furloughs, and to consider reductions in force in light of the economic impact of the COVID. Let's review some of our options. Again, wages, hours of work, furlough, which would be a temporary leave, temporary on reserve type status, generally 6 months or less, and actual RIFs or terminations. Remember, in evaluating all this, we need to do our best to look at our bottom line, our cash reserves, cash flow, what can we expect in the future, and that is the wild card, because right now, I don't think there is great guidance, not through any fault of anyone, but we just don't know how long this situation is going to last. Hopefully it won't last as long as some people are saying, and we can get back to a normal outlook fairly soon. But we need to look at where we are financially, what our industry factors and outlook are. When we do have to make these decisions, how do we communicate with our employees? We need to be aware of what our obligations are legally. If we do layoffs and furloughs, we need to make sure we understand what government directives are out there. If we do that in terms of operating our workplace within the parameters of what the federal government is right now guiding us with, okay? We need to make sure we understand our wage and hour laws, how we understand the difference between hourly and salaried employees in terms of how that reduction in force, how reduction in hours, for example, would impact them, as we'll see in our questions. Unemployment benefits. Many states, including South Dakota, have made alterations for individuals who are seeking unemployment benefits related to the COVID crisis, where we don't necessarily have to look for other work during the period where benefits may be available sooner. We need to review our benefit plans and policies. As we'll discuss, we need to make sure that if we are laying off 50 or more employees in some situations at a single location, or 100 or more total, that we have complied with our federal WARN obligations. Okay, benefit plans and policies. This is coming up a lot. In this type of scenario, let's say we have full-time employees who we are going to reduce their hours from, and these are non-exempt hourly employees, we're going to reduce hours due to the COVID crisis from 40 hours a week to 20 hours a week. And provided we don't have an FMLA obligation here, and many of you don't because you're less than 50 employees, that may change their ability to be eligible for coverage under your health insurance, under your PTO, etc. And we need to make sure we are familiar with our, for example, health insurance plan document, because if someone's status is changed and they're no longer eligible for benefits, we need to make sure we have communicated that to the employee and communicated that to our insurance carrier so they understand that there is consequence because they are no longer considered full-time and therefore perhaps no longer covered by health insurance, for example. This scenario comes up a lot. I've talked to many of you about it in the last week, where layoffs, reduction in hours are being considered in the scenario where an employer in good faith thinks they're helping their employees by keeping them on, but at a reduced number of hours, and thinks they are keeping their benefits intact, but due to the definition of full-time employee under their benefit, health insurance, whatever, long-term disability insurance, whatever it may be, doesn't realize that they may no longer be eligible for benefits. And that's why we have to communicate with our carriers, get their guidance on what the definition is, and then communicate that to our employees if their hours are being reduced, okay? Again, we need to make sure that if we have an employee, for example, who unfortunately has to be terminated because we don't have enough work for them due to the COVID crisis, we need to make sure we provide them accrued PTO if our PTO policy requires that upon termination. Provide them vacation if your vacation policy requires that upon separation. We need to make sure that we understand what our obligations are if we have to terminate the employment relationship, and we do so uniformly, and we follow our practice and policy. Okay? Now, right now, for private employers, in most every case not governed by a collective bargaining agreement, you are not obligated to provide accrued vacation unless your policy or practice requires it. And that's fairly ambiguous. Most states have laws that require you to pay it upon severance. You may not have to, but again, it will be an individual situation based on what you've done in the past and what your policy says. So make sure you check all of that before you make any decision not to provide a severed employee with accrued vacation and PTO. And if you need to seek guidance on that, reach out to a number of sources, including the SDRA. You can reach out to us at Jackson Lewis as part of the retainer agreement. Okay, without bogging down in the Federal WARN Act, understand that if you are reducing a large number of employees that approach 100 in aggregate or 50 at a single location, you have obligations to provide notice if you can. And in many cases, we can argue due to the COVID crisis, we cannot provide the 60 days notice, but we still need to provide reasonable notice. And we understand what our WARN thresholds are. I would think most of this group, due to their smaller size, are not going to have WARN obligations. But remember, if you are a larger employer and your layoffs include an aggregate of 100 or 50 more at one particular site, you should get advice on what your obligations are to provide a WARN notice, okay? Now, before we get to the questions, remember on wage and hour issues that if we are, we can make deductions from salary for hourly employees if we don't have enough work for them. But if we have an exempt employee on salary and they start working on a Monday and they get halfway to Tuesday and we say, hey, we don't need you the rest of this week, for example, generally we're going to have to pay them for that whole work week. So keep that in mind as we're reviewing our reductions for salaried exempt employees, because if we don't follow the restricted rules on deductions for exempt employees, we risk and jeopardize their salary exemption, their exempt status, and therefore may be obligated to pay them overtime. Remember, we can reduce an exempt employee's salary on an indefinite basis. We can say, hey, due to circumstances related to the COVID, we are going to have to reduce your salary, and many employers are contemplating that now, provided we still meet the current minimum annual of $35,568 per year and $684 per week. In order to classify someone as exempt and not have to pay them overtime, they still have to meet this minimum threshold. Also remember, because we are having scenarios where employees are asked to work remotely, which allows them to continue working in an isolated manner to promote safety, as is recommended by state, federal, and local governments, that those folks must be paid in full for hours worked. We need to establish protocols for when they are to be working. We need to establish protocols as to how their time will be recorded. And again, we're talking about hourly non-exempt employees. And we must make sure that they are, to the best of their ability and our ability to monitor, accurately keeping track of their time. And there are scenarios where someone will say, hey, due to the crisis, for example, I've worked 36 hours in the last 2 days, and I just thought I'd let you know that. And they may say, I'm just trying to chip in here. You only need to pay me for 16 because those are 2 8-hour shifts. Don't worry about the other 14 that I've spent all night working trying to help the business. And obviously, if they engage in work, these hourly non-exempt employees, even if they're working at home, even if we didn't authorize them to work that number of hours, if they work those hours, they must be paid for those hours. That's why we have to set up protocols, for example, approval for overtime and the like if you're working at home, set up ways to monitor and accurately record time, okay? Now, remember, again, to reiterate, generally, if somebody is out on FMLA leave, and including the expanded reason we talked about for childcare related to closure of schools or healthcare providers, that we have an obligation to continue their coverage, and the employer and the employee contributes the same amount in premiums collected on a monthly basis as before. If this leave is not FMLA leave, we need to evaluate how the layoff or furlough or decrease in hours affects coverage. and that may trigger on a termination or a reduction in hours. That may trigger and will trigger if they're no longer a covered employee, for example, an eligible employee under their health insurance. That may trigger our obligations under COBRA, and we must make sure our COBRA notices are timely sent. Okay, I know this is a lot of information, but hopefully all of you are at least in some way able to red flag a number of these issues as we move forward. Okay, specific as to South Dakota, and again, this is on the SDRA, much of this is on the SDRA website, but flag the following. As most all of you know, Governor Hoyme issued an executive order on Monday. That executive order is referenced on the website, and in a nutshell, it applies to most all governmental and private employers. It addresses enclosed retail businesses that promotes public gatherings, that applies to restaurants, bars, etc., and advises and recommends, for example, that they allow no more than gatherings of 10. I'm sure all of you are monitoring that closely. That executive order is very helpful in terms of guidance for you medium and small employers. Right now, that order is simply, even though it says order, it is a recommendation that these guidelines be followed, subject to local, county, and city orders that have been issued, and we're going to discuss those in just a minute. But make yourself, get yourself up to speed on that executive order, understand the type of business that it applies to and whether it applies to you. Right now it is a recommendation, but for all of you that watched the governor and I did indicate that this is very serious, and she strongly recommends that it be followed. Also, as unfortunately some of you may be required to lay off, reduce hours of your employees presently due to this COVID crisis, there are opportunities under unemployment, reemployment assistance from the state. The SDRA website has great examples of how this would apply. For example, in the scenarios that are presented by the reemployment assistance website, it says, what if a worker has tested positive for COVID-19 and is temporarily unable to work? In that case, a claim would need to be filed online by the employee, and they would not be expected to actively seek employment as long as that layoff was no longer than 10 weeks. But the key to the game is, if that layoff occurs, that your employee immediately get online to the raclaims.sd.gov website that's set forth on the SDRA website under reemployment assistance, file a claim and get the benefits moving forward. What if a worker is out of work because their employer closed due to COVID-19? Again, the same applies, and they would not be required to actively seek work as long as the layoff did not last longer than 10 weeks. Another question, what if a worker has their hours reduced because of a reduction in force related to COVID-19? There are partial reemployment assistance benefits available in a calculation that this website provides. You need to get on the RA website, and that provides that formula for filing a claim in the event of reduced hours. What if a worker is sent home from work because the employer thinks they are at risk or they are at risk? They are likely eligible for reemployment assistance benefits and should get on the raclaims.sd.gov website to file their claim and seek information. What if a worker chooses to self-quarantine and is unable to work? meaning they don't have symptoms necessarily. They don't have a doctor's note saying they are at high risk specifically because of COVID. Generally in that case, and again, I stress, it's individual, but if an employee just refuses to go to work and says, I'm self-quarantined, I'm not comfortable in the workplace, they probably would be not eligible for reemployment assistance in that case. Those are some of the examples given on the website that may be applicable to you. Likewise, a portion of the website, again, the SDRA website, the COVID-19 page, has an up-to-date South Dakota city closure listing. As recently as Monday in Brookings, as recently as effective today in Deadwood, for example, as it applies to gaming operators. Huron had a closure order issued March 22nd. Rapid City had a closure, our first reading of a closure order schedule, a second reading scheduled for March 27th as to whether or not they're going to have a closure order. Watertown, beginning March 26th, has a closure order applicable to some on-site food and beverage entities. Wessington Springs passed a resolution on March 23rd to move all restaurant, bar, and local business to curbside and drive-through. For all of you, frankly, for all of you, period, you should monitor that closure update on the SDRA website to see if you have any specific county or city closure orders applicable to your business. Even though the executive order by Governor Hoyme said we're making these strong suggestions, it is subject to, you are subject to these local closure orders if indeed you are within that jurisdiction. Likewise, be aware, and it's also listed on the SDRA website, that there is small business associated economic assistance directed at South Dakota small businesses to provide disaster loan relief and other relief for South Dakota small businesses. There is a website that is listed on the SDRA website where you can go to get information and get, if you qualify, get the application process going to provide you potential economic relief if you are being economically damaged by this current crisis. Finally, again, to stress the information resources on the SDRA website, the Jackson Lewis website. What the SDRA website does is provide links to both city, state, federal, professional such as Jackson Lewis resources to get you up to date on a variety of sources. As an aside here, I know the SDRA has been getting a number of calls and emails regarding this crisis as expected. I know I have been getting a number of calls and emails on this issue as expected, and we will respond to those as we get them. However, as kind of a best practices, if you have an issue, before you contact the SDRA or Jackson Lewis or whatever, take a look at that website, get some input from your local government, review the Q&A that Nathan talked about that we're going to get up on the SDRA website ASAP, because your answer to your question probably will be within those resources and you won't even need to reach out to us. Obviously and emphatically, if you still need to reach out to the SDRA or Jackson Lewis through the retainer agreement, please do not hesitate to do that. Okay, some quick, not quick, we're going to run through questions. All right. How much information may you request from an employee who says, who says they are sick. The ADA generally prohibits such information. However, I'm going to try to move this. Okay. How much information may you request from an employee who says they're sick? The ADA now contains an exception where there is a direct threat of harm to the health and safety of coworkers to inquire. And this does constitute a direct threat in most cases, and you can inquire. All right? Can we ask about someone who has exhibited symptoms of COVID-19? Generally, the answer is yes. Is it a violation of the ADA to take body temperatures, for example? Not a violation. However, understand that not all individuals, based on studies and data to date, not all COVID-19 diagnosed people have a fever, okay? It is not a violation of the ADA to require a fit for duty release for an individual who has been away due to concerns of COVID-19, which covers a number of questions that we have received from you. Second question, what can you do if an employee is showing symptoms of COVID-19? You may ask if they are experiencing influenza-like symptoms, such as fever, cough, and chills. You may send an employee home if they display influenza-like symptoms. You may and should encourage employees to telework if that's possible. You may require infection control practices and should, such as regular hand washing, hygiene maintenance, coughing and sneezing. May you require employees to wear personal protective equipment? Yes. Remember, you should also always maintain medical information as confidential, and we cannot and should not get into very specific conversations about an employee's medical condition that may be vulnerable to the COVID. We should simply talk, are they symptomatic? And if they bring a doctor's note that said due to an underlying condition, we immediately take precaution, probably send them home, remove them from the workplace and the like. But under the direct threat standard, you are allowed to inquire in a much more broad basis than you were under the direct threat exception to the ADA. What if an employee or customer client is confirmed to have COVID-19 after being in your place of employment? The CDC recommends clearly that employees who have been diagnosed with COVID-19 or who have had close contact with an individual confirmed to have COVID-19 should notify Human Resources, be out of the workplace for at least 14 days. Employees who live with an individual who is a confirmed positive are considered within the definition of close contacts. You should immediately remove them, ask them to leave, but get them out of the workplace for at least the quarantine period in that circumstance. What if an employer or customer client is confirmed to have COVID-19 after being in your place of employment? You should reach out to your state and local health department to get further guidance if that occurs. You should follow directions from them regarding disinfection. You should work with the CDC and state and local health to identify potential contacts for that individual. You should also, keeping confidentiality in terms of specifics, privacy-wise, definitely do that, but generally you should communicate with your employees and make sure you take every means to protect other employees from that exposure. What steps should employers take in order to continue operating in the event to exposure? Prepare for increased absences, plan to minimize exposure between employees, consider remote work. I know many of us never thought we'd have to do this, but there are many jobs that can be done at home that, based on this safety risk that is significant, that we need to see if there's ways to get folks home. Communicate with your employees about what your protocols are, what your plans are. Plan for supply chain interruption. If you have supply contracts, if you have any type of contractual obligation, whatever it may be, review those contracts to see if you have a force majeure or act of God clause that may allow you some relief from that contract, okay? Now, we received a number of questions from all of you. We're going to try to cover some of those. Some of those questions we have already covered. First question, can a supervisor force an employee to go home if they believe they may be sick? For example, if they appear to be symptomatic. Yes, sick employees should be separated from the workplace immediately. So if you see someone that appears to have symptoms consistent with COVID, cough, sneezing a lot, fever, whatever it may be, you do have the right to ask them to quarantine themselves away from the workforce, all right? Does the leave provision that we've talked about, the new act, First Families, apply to local government? In most cases, the answer is yes. What is the effective date of HB 6001, which is the First Families Act? The effective date is April 2nd. Next question, how quickly will payments come in to those laid off? Generally in South Dakota, it will take 4 weeks. I know there are efforts underway to decrease that time. Likewise, in the event you get a workers' compensation claim related to COVID, South Dakota does have a very specific standard that requires a professional opinion that it is that condition that the employee is seeking workers' compensation benefits from is directly and not collaterally related to the COVID virus. Hopefully that won't happen to any of you, but that standard is out there. It's a fairly onerous professional standard in regard to qualifying for workers' comp benefits. In regard to the tax credit that we talked about, if sick pay has to be paid, we strongly advise consulting with a benefits and tax attorney on the protocols to seek that and get reimbursed under the tax credit provisions of the First Family legislation that we discussed. Next question, if you shut down operations, how long are you required to pay employees? If they're a contract employee, you have to satisfy the contract. If they are an exempt employee, like we talked about, and they work 2 days during the week, and they are not working the remainder because you don't have enough work for them, you would have to pay them for the full week. If they are at-will hourly employees, you're only required to pay them for the hours that they have actually worked, all right? A good question here, legal ramifications of employees working through this pandemic. Am I liable for anything if they are infected, for example, helping customers? Again, this is a fairly general response that needs to be evaluated, and you need to get specific advice on an individual basis. But generally, you are required to provide under OSHA a workplace that is free from recognized hazards. So generally, the standard that would be implied is, did you have reasonable notice that your employee in this case had the COVID-19 virus or had been exposed to it? You can only be responsible for what you knew, and that information must be credible for you to have relied on it or should have known about it. So if you have an employee that says, my father has been diagnosed with COVID-19 and I've been in close contact with my father, you would have an obligation to remove that employee from the workplace until they are through the quarantine period, and I would advise a doctor's note to indicate they are free to return to the workplace before you would keep that employee in the workplace, or you would risk potential liability, okay? What records should we keep regarding workers who are paid administrative leave due to COVID-19? We should document all of that and remember to keep confidential any medical related records or discussion of medical conditions. We need to make sure we establish confidentiality. What are the effects of working from home, a business shutdown, or leave for COVID-19 illnesses that affect both employer and employees? Again, we've covered most of that, but the federal government, state and local governments are advising that where possible, employees should be allowed to work from home if they're hourly, to record their time and to work in a social distancing environment that will keep the virus from spreading. Another question, trying to understand the impact on businesses with less than 15 employees. And again, the new act that we talked about, both the paid leave and the expansion of the FMLA, would indicate that it could be applicable to all employers, regardless of size, but there is an out for those employers that may be 50 or less, if they can show that the economic viability of their business continuing could not survive having to pay that paid leave. All right. Looking at some other questions that haven't been answered. How much do laid off workers get with unemployment? Again, that is established by the state. Many times the formula generally can be 2/3 of what their regular pay is, but again, that's established by the state. A question, if we have to lay off because of this pandemic, will it cause unemployment insurance rate hikes? And the answer is, we don't know. But certainly it could. But at this point in prioritizing issues, one, we don't know, and two, what's the specific legal advice you're looking for from your professional? It is what it is, meaning we don't know, we'll just have to monitor that. Can I require an employee to let me know if they are going to leave the immediate area? If an employee says, I am going to travel into a restricted area, obviously a globally restricted area, we cannot require that they not go there. Or let's say they're going to fly to and return from New York or Los Angeles, or fly in general. We do have the right to say, we want you to quarantine, self-quarantine upon your return, and until that quarantine period has been satisfied, we will not allow you to return to work. Perhaps there is a way they could work from home during that period, but you are given great leeway for folks that elect to travel in ways that put them at risk. I know the federal government came down yesterday and said, if you have, as a citizen, if you are traveling from New York City to other places in the country, you should self-quarantine yourself, for example. So you are given much more leeway in keeping an employee who is traveling from returning to your work site until they have self-quarantined. Another question. How do we handle employees who wish to work from home, but there is nothing they can do at home? And this is going to happen a lot. We're seeing it regularly. And the question is, if they cannot come to work due to a specific SDRA diagnosis, or they are working in close contact with someone who has been diagnosed with COVID, or if they have an underlying condition through a medical professional diagnosis that would be exacerbated by COVID, or they are staying home because their children cannot go to school for a COVID-related closure, if they don't fit in any of those buckets that we have discussed, then they would not be eligible to continue employment. They could be laid off certainly, hopefully in a furlough type situation, and you would direct them to the reemployment assistance benefits that we have discussed. Finally, there's a question regarding foreign workers under programs such as H-2B visas and J-1 visas. Will they be allowed? And the government right now is coming out with very specific changes and allocations to those visa programs. We will attempt to get that on the SDRA website in short order. Certainly there is guidance on the Jackson-Lewis website if you have foreign workers subject to visa requirements, applications, and qualifying criteria. That is all I can say without taking a breath in an hour. We wish you all well. If you have questions after reviewing all of your local, state, and federal resources from the links provided by the SDRA or anything else, clearly you can direct those questions. I would request to me an email form and contact us or the SDRA, and we will attempt to answer those. My contact information is set forth on this screen. Phone number 402-827-4232, email christopher.hoyme@jacksonlewis.com. Again, we wish you the best. Please be safe, and hopefully we can navigate all of this and be safe, and at the same time keep our businesses running. So thank you very much, and I'll turn it back over to Nathan.
Thanks, Chris. Really appreciate your time today. Just a couple of wrap-up comments. First, a reminder, we're going to email out a link to an archived version of this webinar later today. And so you will receive that link so that you can review it again. There was a lot of rapid-fire Q&A at the end, and so that's an opportunity to review that. Chris had mentioned it multiple times, but SDRA.org has a pretty robust COVID-19 website. We would encourage you also to check out that community tracker. We're trying to link to all of the ordinances that we can find that are restricting businesses beyond what Governor Noem's executive order included. If you are aware of communities that have passed ordinances that are not on the website, by all means email us, and you can email us at the same email address that you would send questions to. That's info, I-N-F-O, at sdra.org. info@sdra.gov, or .org, info@sdra.org. Finally, we're having multiple webinars coming up, and those are listed again on that COVID-19 page, but particularly Friday's webinar with the Department of Labor and Regulation related to unemployment insurance, or reemployment insurance as the term now is. A lot of good opportunities to ask questions of DLR then. So in the meantime, stay safe, continue to be creative and innovative with your businesses. We're going to keep trying to get you information. Thank you to Chris Hoyme again, and thanks to you for participating.